Advanced Audits and Assurance. Chapter 5. Practice Management. Content 1. Quality Control, ISA 220 and ISQC 1. 2. Changes in professional appointment. 3. Obtaining and charging for professional work. 4. Agreeing the terms of audit engagement, ISA 210. 5. Chapter Review. Introduction. Competencies. Legal, regulatory, and ethical issues. Identify and make judgments upon when it may be appropriate to refer a matter to a more senior colleague or for third-party advice or consultation. Accepting engagements and managing assignments. Analyze and evaluate the issues during the process of obtaining audit work. Identify and explain the legal, professional, and ethical issues during the acceptance of assurance or audit engagement. Evaluate and apply appropriate procedures and personnel for management of an assurance or audit engagement. Evaluate and apply appropriate quality control measures that may be used by a firm during the course of an assurance or audit engagement. Evaluate and apply appropriate monitoring and review procedures to effectively manage an audit or assurance engagement. Identify and explain the purposes and how external monitoring of audits and assurance engagement might operate to ensure firm or engagement quality. Analyze and evaluate the considerations for an auditor of risk issues identified prior to accepting an engagement. Analyze and evaluate how engagement terms can be agreed and recorded by an auditor, including those agreed with a client and those imposed by law or regulations. Exam context. This chapter continues the theme of practice management introduced in the previous chapter. You need to fully understand the system of quality control used in an accountancy firm, incorporating both ISQC 1 and ISA 220. You also need to understand the commercial, legal, and ethical parameters around changes in professional appointment and the process of obtaining and charging for professional work. By the end of this chapter, students will be able to 1. Describe the components of a system of quality control applied to a firm of accountants performing audits and assurance engagements. 2. Explain the process around changes in professional appointments, including legal, commercial, and ethical considerations. 3. Apply ISA 210 in agreeing the terms of an engagement. Subtopic 1. Quality Control, ISA 220 and ISQC 1. It is important to remember that a firm of external auditors is a business whose objective is to make a profit. This business is subject to regulation, such as the regulation of quality control and fees regulation, and the nature of the regulations may influence the way the business is managed. This chapter looks at business aspects of running an audit practice that are sometimes referred to as managing the client-auditor relationship. Section 1.1. The need for a quality control system in accountancy firms. The IFAC and ICAN codes of conduct both require that members should perform their professional work with due skill and care and with a proper degree of technical competence. Audit work may be performed by members of a large team of auditors, that is the engagement team. If so, the members may have different levels of knowledge and experience. To satisfy the professional requirements for due skill and care and technical competence, audit firms need to have a strong system of quality control. Good procedures for quality control should reduce the risk for the audit firm that it will issue an incorrect audit opinion and be sued for negligence. The consequences of poor audit work and legal action by the client could be any or all of the following. 1. Legal damages and legal costs. 2. The loss of the client. 3. Adverse publicity and damage to the reputation of the audit firm. 4. Disciplinary proceedings by a professional body such as ICAN. It is also important for the audit profession as a whole that all audit firms should have good procedures for quality control. If the profession as a whole gained a reputation of poor quality audits, its public image would be damaged. Section 1.2 Quality Control Procedures. Quality control procedures can be considered at two levels. 1. The audit firm as a whole. 2. Each individual audit engagement. Section 1.3 Quality Control Arrangements for Individual Engagement, ISA 220. The objective of the auditor, as set out in ISA 220, Quality Control for an Audit of Financial Statements, is to implement quality control procedures at the engagement level to provide reasonable assurance that the audit complies with professional standards and applicable legal and regulatory regulations, and the audit report issued is appropriate. This means that quality control procedures should be implemented that are applicable to the individual audit engagement. ISA 220 places the responsibility for key quality control matters on the engagement partner. The engagement partner has responsibility for the overall quality of the audit and is required to put procedures in place to ensure that 1. Ethical standards are complied with and appropriate action taken if there is evidence to the contrary. 2. Independence requirements are met, including identifying circumstances and relationships that might give rise to threats to independence, assessing the impact of breaches of the firm's independence policy and procedures, and whether such breaches create a threat to independence. Taking suitable action to eliminate identified threats or to withdraw from the engagement if appropriate. 3. Procedures are in place to deal with the acceptance of new engagements and the continuance of existing engagements. 4. The audit is carried out by an audit team with the appropriate competence and capabilities. 5. Appropriate management of the engagement is in place, including the direction and supervision of staff and the review of audit work. On or before the date of the audit report, the engagement partner must, through a review of audit documentation and discussion with the audit team, be satisfied that sufficient appropriate evidence has been obtained to support the conclusions reached. 6. Adequate consultation has taken place on difficult or contentious matters and the conclusions from such consultation implemented. 7. An appropriate monitoring system is in place. 8. The following matters are documented. Issues in respect of compliance with ethical requirements and how they were resolved. Conclusions on compliance with independence requirements. Conclusions in respect of new and continuing engagements. The nature and scope of conclusions from consultations undertaken. 8. For audit of listed companies and any other audit where the firm has determined that an engagement quality control review is required, the engagement partner is also required to appoint an engagement quality control reviewer who performs an objective evaluation of the significant judgments made by the audit team, and the conclusions reached, including discussion of significant matters with the engagement partner, review of the financial statements and the proposed audit report, review of selected audit documentation relating to significant judgments, and evaluation of the conclusions reached and whether the proposed audit report is appropriate. 9. Considers the engagement team evaluation of the firm's independence in relation to the audit engagement. 10. Considers whether appropriate consultation has taken place on difficult or contentious matters. 11. Considers whether audit documentation selected for review reflects the work performed and the conclusions reached. The engagement quality control reviewer is required to document confirmation that 1. The firm procedures in respect of engagement quality control reviews were followed. 2. The review was completed on or before the date of the audit report. 3. He is not aware of any unresolved matters that would cause him to believe that the significant judgments made by the audit team and the conclusions they reached were inappropriate. More detail on many of the above procedures is given in a later section. Section 1.4 Quality Control Arrangements at the Overall Firm Level, ISQC 1. Quality control policies and procedures at a firm level are set out in ISQC 1. Quality control for firms that perform audits and reviews of financial statements and other assurance and related services engagements. The objective of the firm, as set out in ISQC 1, mirrors that of the auditor in ISA 220. The objective of the firm is to establish and maintain a system of quality control to provide it with reasonable assurance that 1. The firm and its personnel comply with professional standards and applicable legal and regulatory regulations, and 2. Reports issued by the firm are appropriate. The quality control procedures that are applied within an audit firm reflect the nature and size of the audit practice. However, personnel within the firm who are responsible for establishing and maintaining quality control procedures must have an understanding of the entire text of ISQC 1. As the firm must meet the requirements of ISQC 1, it should have a system in place which addresses each of the following elements. 1. Leadership responsibility for quality. 2. Ethical requirements. 3. Acceptance and continuance of engagement. 4. Human resources. 5. Engagement performance. 6. Monitoring. 7. Documentation. The requirements of ISQC 1 in each of these areas are considered in turn. Leadership responsibility for quality. ISQC 1 requires the firm to establish policies and procedures designed to promote an internal culture recognizing that quality is essential. Ultimate responsibility for quality control policies and procedures should rest with the firm's CEO or equivalent, or managing board of partners or equivalent. Any person who has operational responsibility for quality control should have appropriate experience and ability and the necessary authority. Ethical requirements. ISQC 1 requires the firm to establish policies and procedures to provide it with reasonable assurance that the firm and its staff comply with relevant ethical requirements and maintain independence where required to do so by those requirements. The firm should communicate its independence requirements to staff and identify and evaluate circumstances and relationships that create threats to independence, assessing the impact of such threats and applying safeguards or withdrawing from the engagement if appropriate. The policies and procedures should include requiring staff to notify the firm of circumstances and relationships that might create a threat to independence, requiring staff to notify the firm of any breaches of independence of which they have become aware, requiring the firm to communicate such breaches to the engagement partner and other relevant staff, requiring the engagement partner to advise the firm of action to be taken. At least annually, the firm should obtain written confirmation from all staff of compliance with the firm's policies and procedures on independence. The firm should also establish criteria for determining the use of safeguards to reduce the familiarity threat to an acceptable level when the same senior personnel have been used on an assurance engagement for a long time. For listed entity clients, there must be rotation of the engagement partner after a specified period in compliance with relevant ethical requirements. Acceptance and continuance of engagement. ISQC 1 requires the firm to establish policies and procedures to provide it with reasonable assurance that the firm will only take on or continue work where the firm is competent to perform the engagement, has the capabilities including the necessary resources to do so, can comply with the relevant ethical requirements, and has considered the integrity of the client and does not have information which would lead it to conclude that the client lacks integrity. The policies and procedures should include requiring the firm to obtain sufficient information to make such decisions for new or existing engagements, consider potential conflict of interest and therefore whether it should accept the engagement, document all identified issues and how they were resolved. This requirement means that there should be a review of proposed new clients and at regular intervals of existing clients to make sure that the firm will be independent, that there are no conflict of interest, and the firm has the technical competence to do the audit work. When an audit firm accepts an audit engagement from a new client, suitable procedures should therefore be carried out to ensure that the firm will be independent and there are no conflicts of interest. The firm has the technical competence to do the work. Professional clearance has been obtained from the previous auditors of the new client. Appropriate anti-monetary laundering, client identification procedures are performed. Before the start of the audit each year, the engagement partner for the audit should ensure that all members of the audit team are independent of the client and there are no conflicts of interest, and be satisfied with the ethical integrity of the client entity and its management. Human resources. ISQC 1 requires the firm to ensure it has sufficient personnel with the competence, capabilities, and commitment to ethical principles to meet its overall quality control objectives, and that for each engagement, an appropriate engagement partner and team are assigned. Policies should therefore exist for the recruitment, training, and development of staff. The firm should ensure compliance with ISAs, and audit staff should have a good knowledge of accounting standards and local or national statutory accounting regulations. The firm's technical auditing procedures should be set out in a manual and reinforced by training. Newsletters and/or meetings could be used as a means of ensuring that professional staff are kept up to date on current developments. Work should be assigned to staff that are competent to perform that work. There should be procedures for ensuring that an audit team collectively has the appropriate level of technical knowledge for the audit engagement and includes individuals with the experience of audit of a similar complexity and an ability to apply professional judgment. Engagement performance. Policies and procedures are required to include 1. Those to promote consistent quality engagement performance. 2. Supervision responsibilities. 3. Review responsibilities on the basis that more experienced team members review the work of less experienced team members. 4. Guidance on consultation to ensure that appropriate consultation takes place on difficult or contentious matter. Sufficient resources are available for such consultation. The nature, scope, and conclusion of the consultation are documented by both parties. Conclusions arising from the consultation are implemented. 5. Guidance on engagement quality control reviews to ensure that an engagement quality control review is required for audit of all listed entity clients. Criteria are established to determine which other engagements should be subject to an engagement quality control review. The review covers certain procedures, the same as set in ISA 220, see above. Engagement quality control reviewers are eligible to carry out such reviews via technical qualifications, experience, authority, and objectivity from the engagement. Engagement quality control reviews are properly documented, again, as also set out in ISA 220. 6. Procedures for dealing with any difference of opinion between the engagement team and those consulted, or between the engagement partner and the engagement quality control reviewer. 7. Procedures in respect of completion of the final audit file on a timely basis and the confidentiality and safe custody of such documentation for an appropriate period. Monitoring of quality control procedures. The firm is required to establish a monitoring process designed to provide it with reasonable assurance that its quality control system is relevant, adequate, and operating effectively. This process should include inspecting on a cyclical basis at least one completed engagement for each engagement partner. Responsibility for the monitoring process should be given to a partner or other appropriate person with sufficient experience and authority. When monitoring review, also referred to as code reviews, are carried out, they should not be performed by those involved with the engagement or the engagement quality control review. The firm should evaluate the effect of any deficiencies found to determine if they do indicate a failing in the firm's quality control system. Communicate such deficiencies to relevant personnel together with appropriate remedial action. Appropriate remedial action might include 1. Actions in relation to individual engagements or employees. 2. Communication of findings to those responsible for training and professional development. 3. Changes to the firm's quality control system. 4. Disciplinary action, especially against repeat offenders. If the result of monitoring procedures indicates that an inappropriate report may have been issued or processes were omitted during the engagement, the firm should determine what future action is needed. This might include obtaining legal advice. The firm should produce an annual report for partners, setting out the monitoring procedures performed, the conclusions drawn, any systematic deficiencies found, and remedial action taken. The monitoring system should include procedures for dealing with complaints and allegations against the firm. This should include establishing channels through which employees can come forward without fear of reprisals. Documentation of quality control procedures. The following matters are required to be documented. 1. Evidence of the operation of each element of the system of quality control. 2. Complaints and allegations made against the firm and how these were resolved. Documentation must be retained for a sufficient period of time as a minimum to comply with relevant laws and regulations. Section 1.5. Quality control procedures specific to individual engagements. The quality control procedures applied to the conduct of each individual audit engagement will be based around the effective management of the audit team working on that engagement. This will involve the direction and supervision of staff and review of their work. Direction of audit staff. The direction of audit staff is the responsibility of the engagement partner for the audit. Direction is achieved by the following methods. 1. The audit team members should be informed of the work they are expected to carry out and the objective that the work is intended to achieve. 2. There should be a well-prepared audit work program, and staff should be familiar with the overall audit plan. In addition, the members of the audit team should understand their responsibilities, the nature of the business of the client company, risk-related issues, problems that may arise with the audit and how these problems should be dealt with if they do occur, the detailed approach to the performance of the audit work. The members of the audit team should maintain an objective state of mind and retain their independence, perform their work with due care, and raise any questions that might have with more experience they might have with more experienced members of the audit team. Supervision of audit staff. Supervision should continue throughout the audit. It includes the following. 1. Tracking the progress of the audit. 2. Monitoring the competence of team members, including whether they have sufficient time to carry out their work, whether they understand their instructions, whether they are carrying out their work in accordance with the audit plan. 3. Addressing significant issues that arise during the audit, assessing how significant they are, and modifying the audit approach accordingly. 4. Identifying where there is a need for an audit team member to consult more experienced members of the team. 5. Monitoring the behavior of team members, particularly inexperienced junior members of the team, to ensure that they maintain ethical standards. Review of audit work. Review of audit work is a key aspect of quality control. All audit work should be reviewed, ideally by an auditor with a higher level of competence and experience than the audit team members who performed the audit work. The review process may take any of the following forms. 1. Peer review. This is a review carried out by another partner in the assurance firm. 2. Engagement Quality Control Review, EQCR. A peer review performed before the audit report is signed as required by ISQC 1 during the audit of a listed or public interest entity. An EQCR forms part of the quality control procedures specific to an individual assignment. 3. Audit review. Similar in substance to an EQCR, except that the audit review is not performed as a direct requirement of ISQC 1. E.g., when an engagement partner on a non-listed or public interest entity audit wants a second opinion or to monitor the work of a new partner during probation. 4. Monitoring review, also called a code review. This is a peer review performed after the audit report is signed. A code review forms part of the monitoring of quality control procedures. The purpose of audit review is to check whether the audit work was carried out to proper professional standards, the objectives of the audit have been achieved, the work carried out during the audit and the audit evidence are suitably documented, and that the audit evidence supports the conclusions that have been reached. The review of the audit work should cover 1. The audit planning process, 2. Audit procedures including documentation, that is the audit working paper, the audit test performed and the audit evidence gathered, compliance with audit work program, the resolution of problem encountered on the audit. 3. Whether the conclusion reached is consistent with the audit evidence obtained and documented. The review process itself should also be documented. Review by the engagement partner and audit manager. As discussed above, before the audit report is issued, the engagement partner needs to be satisfied that sufficient appropriate audit evidence has been obtained to support the conclusions reached and for the audit report to be issued. It should therefore review the audit documentation and hold discussions with the audit team. This process is usually referred to as the partner's review. It should be scheduled into the audit plan towards the completion of the audit. Before the partner's review, the audit senior should try to ensure that every file is complete and cross-referenced in order to cut down the number of points that might be raised by the partner's review. The partner's review will usually be preceded by a manager review, in the hope that the audit manager will identify some matters that can be resolved before they come to the attention of the engagement partner. Assessing the adequacy of quality control. An examination question that asks you to discuss the adequacy of quality control in an audit will probably expect you to identify weaknesses in the conduct of the audit, such as 1. Poor or inadequate planning of the audit, such as a failure to identify the key audit risk. 2. Giving complex audit work to relatively inexperienced members of the audit team. 3. Inadequate supervision. 4. Inadequate review of the audit working papers by the audit manager. Example: quality control issues. An audit firm has just carried out the annual audit for a client company. The audit manager has just learned that during the audit planning process, a junior member of the audit team, who is an IT graduate from a major university, gave advice to the client about improvements that could be made in the client's finance and the accounting IT system. What professional and ethical issues exist in this situation? Answer: the situation raises some questions about quality control in the audit. 1. Junior members of an audit team must be given suitable directions about their responsibilities, and their activities should also be properly supervised. In this situation, a junior member considered that he was allowed to offer advice to the client, which clearly should not be the case. This suggests poor direction and supervision in the audit. 2. The junior member obviously believed that he could offer advice directly to the client. In practice, if any member of the audit team identifies weakness in the client's internal controls, their findings should be reported to a senior member of the audit team, who should then decide the appropriate action to take. Failure by the junior team member to report his findings to a senior auditor also raises a concern about quality control. The firm may require much better training of staff about audit responsibilities and procedures. 3. It is important to establish the details of the advice that the junior team member has given to the client and to find out whether the client has acted on that advice yet. The audit partner should discuss the situation with the client's management in order to find out whether the advice has been acted upon. If the client has acted on the advice and this advice was poor, the audit firm may be liable. Section 1.6 Quality control in large accounting firms and small accounting firms. Quality control in large firms. Large international practices operate in several countries with local partnership and offices further down the chain of control. Local partnership and offices within a large practice will have access to 1. Regional and national training programs, 2. The firm's comprehensive audit manual, 3. A central technical department available to answer technical questions from any office or local partnership, 4. In-house technical publications, 5. A firm's standardized audit documentation, 6. A formal system of inter-office reviews. Quality control in small firms. The need for quality control in a small firm is just as important as for large firms. However, many of the facilities listed above are not available to small firms because they cannot afford them. Alternative arrangements for quality control might include 1. Reciprocal arrangements for review and consultation with other audit firms. 2. The use of audit manuals and standardized documentation from third parties or professional bodies. 3. External training and sending staff on courses provided by third parties or professional bodies. Subtopic 2. Changes in a professional appointment. Section 2.1. Why a change might arise. An ICAN member may be asked to accept a new audit appointment in a situation where the previous auditor, that is the old auditor, will not be reappointed. This may be for any of the following reasons. 1. The current firm is too small to cope with the demands of an expanding client who now operates from multiple locations in different towns or countries. 2. There may be a change in the composition of the company's board of directors, and the new directors which wish to appoint an auditor of their own choice. 3. There may be a perceived lack of independence, possibly one that has just arisen. 4. There may have been a disagreement between the directors and the old audit firm, for example, over the accounting treatment of an item in the financial statement. 5. There may have been a loss of confidence in the old audit firm. In theory, the auditor is appointed by the shareholders. However, in practice, recommendations are made by the directors to the shareholders when they consider that there should be a change of auditors. If the outgoing auditor feels that the change is for a reason that should be brought to the attention of the shareholders, for example, in the case of dispute, then national legislation will allow him to make representations to the shareholders. In Nigeria, Section 362, 364, subsection 1D and 3, 365, and 366 of the Companies and Allied Matters Act 2004 deal with the removal of auditors. Removing an auditor before the expiration of his term of office, resignation of auditors, and the right of resigning auditor to requisition a company meeting, respectively. Section 2.2. Procedures before accepting a new audit appointment. Before accepting an appointment, the auditor should take the following steps. 1. It should assess whether there are any professional problems attached to accepting the engagement. This might include, for example, problems of lack of independence, or a lack of technical expertise, or a conflict of interest. 2. It should ensure that resources are available to complete the audit assignment. In particular, it must ensure that there will be sufficient staff of the right level of expertise available at the right time. 3. It should take up references on the proposed client's company and its directors if they are not already known to the auditors. This is usually referred to as client screening. 4. It should communicate with the incumbent or existing auditors, if there are any, to discuss the appointment, the client, and the audit work. The method of communication is referred to in ICAN's Code of Conduct as professional inquiry. See below. Client identification. In order to comply with anti-money laundering regulations, the audit firm should carry out client identification procedures. The purpose of this procedure is to confirm that the client is who he says he is, and that there are no grounds for suspicion that the client may be involved in money laundering activities. 1. If the client is a company or other business entity, documentary evidence of the identity of the entity should be obtained, for example, a certificate of incorporation in the case of a company. 2. Evidence should also be obtained to confirm the address of the entity, such as headed letter paper. 3. If the client is an individual, evidence of identity can be obtained from a passport or driving license, and evidence of address possibly from a recent utility bill. 4. The audit firm should consider whether the business of the potential new client makes commercial sense. For example, it would not make sense for a very large company to be engaged in operating a number of dry cleaning shops, because the size of the company would be too large for the nature of its business operation. When this happens, the client's declared business may simply be a front or cover for hidden illegal activities. In most cases, the client identification procedures should be a formality, and the client may be surprised that they are necessary. The audit firm should explain the regulatory purpose of client identification to remove any doubts or concerns that the new client may have. Professional inquiry. The firm should communicate with the current auditor, if there are any, to establish if there are any matters that it should be aware of when deciding whether or not to accept the appointment. Although this is partly a matter of courtesy between professionals, this will involve discussion of the appointment, the new client, and the audit work. Such discussion will allow the firm to decide if the client is someone of whom it would wish to act. The following points should be noted in connection with communicating with the current auditor. 1. When a member is first approached by a prospective client to act or be nominated, he should explain that he has a professional duty to communicate with the existing auditor or advisor. 2. Client permission is required for any such communication. If the client refuses to give its permission, the appointment as auditor should not be accepted. 3. If the client does not give the current auditor permission to reply to any relevant questions, the current auditor should communicate this fact to the prospective auditor, who should subsequently not accept appointment. 4. If the current auditor does not provide any information relevant to the appointment, the new auditor should accept or reject the engagement based on other available knowledge. 5. The existing auditor or advisor should answer without delay the communication from the prospective auditor. If there are no matters of which the latter should be aware, the existing auditor or advisor should write to say that this is the case. 6. If, however, there are such matters, he should inform the prospective auditor of those facts within his knowledge of which, in his opinion, the prospective auditor should be aware. It is not sufficient to state that unspecified facts exist. 7. The existing auditor or advisor might prefer to explain this fact orally, and the prospective auditor or advisor should be prepared to confer with the existing auditor or advisor if the latter is so desired, and each should make his own record of such a discussion. 8. If an issue of conflicting viewpoints between the client and himself has been raised by the existing auditor in his reply, the prospective successor should discuss the conflict with the client and satisfy himself either that the client's view is one which he can accept as reasonable, or that the client will accept that the incoming auditor or advisor might have to express a contrary opinion. 9. Where the existing auditor or advisor does not respond within a reasonable time, the prospective successor should endeavor to contact the existing auditor by some other means, for instance by telephone, fax, mail, or email. 10. Should this fail, and where the prospective successor has no reason to believe that there are untoward circumstances surrounding the change, he should send a final letter by recorded delivery service stating that unless he receives a reply within a specified time, he will assume that there are no matters of which the existing auditor is aware that should be brought to his attention. A member who accepts nomination in such circumstances is not precluded from complaining to the institute that the existing auditor did not respond to his inquiry letter. 11. If the prospective auditor is satisfied that he can properly act and is prepared to accept nomination or appointment, he should so inform the client in writing. Unpaid fees. A member in public practice should not accept an audit assignment previously carried out by another member without first ensuring that the other member has been properly removed from office as auditor, and that all outstanding fees due to the other member have been fully paid. Confidentiality. The prospective auditor should ordinarily treat in confidence any information provided by the existing auditor. However, it may be essential to the fulfillment of a prospective auditor's obligation that he should disclose such information. It may, for example, be unavoidable for the prospective auditor to disclose to officers or employees of the client matters brought to his attention by the predecessor firm, which needs to be properly investigated. Such disclosure should be no wider than is necessary. Defamation. It is likely that an existing auditor who communicates to a prospective auditor matters damaging to the client or to any individual concerned with the client's business will have a strong measure of protection where any action for defamation to be brought against him, in that the communication will be protected by qualified privilege. This means that it should not be liable to pay damages for defamatory statements, even if they turn out to be untrue, provided that they are made without malice. Joint auditor. A member whose firm is nominated as a joint auditor should communicate with all existing auditors and be guided by similar principles to those set out in relation to nomination as an auditor. Where it is proposed that a joint audit appointment becomes a sole appointment, the surviving auditor should communicate formally with the outgoing joint auditor. Vacancy. A member whose firm is invited to accept nomination on the death of a sole practitioner auditor should endeavor to obtain such information as he may need from the late practitioner's alternative, where appropriate, the administrators of the estate or other relevant sources. Additional work. A member invited to undertake recurring or non-recurring work which is additional to and related to continuing work carried out by another chartered accountant or advisor should normally notify that other chartered accountant of the work he has been asked to undertake. 1. It is generally in the interest of the client that the existing auditor be aware of the nature of the additional work being undertaken. The existing chartered accountant will be provided with the opportunity to communicate with the member to provide information, lack of which might otherwise prevent the additional work from being carried out effectively. Additionally, such notification could affect the way an existing chartered accountant discharges his continuing responsibility to his clients. 2. Notification should always be given to the existing chartered accountant. 3. Provision of all opinions on the application of accounting standards or principles clearly requires particular sensitivity to avoid adversarial positions between an auditor and other chartered accountants wherever possible. Section 2.3. Deciding whether to accept a new audit appointment. An accountancy firm may occasionally decide that to accept a new audit appointment would threaten the firm's reputation and might also raise serious ethical issues. Example, accepting a new audit appointment. Buckle Company is an owner-managed company. It has asked your firm to become its auditors. The following information has been obtained about the company, mainly from the company's current auditors. 1. The current auditor have just resigned from the audit because they no longer have sufficient resources to carry out the audit work for Buckle. They had taken on the audits 2 years earlier after the previous auditor have resigned due to a dispute about fees. The current auditor commented that the company's management liked to keep a close control over costs and they had agreed to do the audit for a lower fee. 2. The current auditor has discovered a number of internal control weaknesses in Buckle and had reported them to management, but nothing appeared to have been done by management to improve the control system. 3. There were ongoing disputes with the tax authorities about the amount of tax payable by Buckle on profits for the previous 3 years. 4. Buckle Company has a poor public relation image. It is currently under investigation by both the police authorities and the regulatory authorities for alleged breaches of regulation, and some of these had been widely reported. 5. The company is ambitious and plans to expand its business in the next year or so. It is expected to obtain bank loans to finance most of the expansion. What issues should the audit firm consider when deciding whether or not to accept the new audit appointment?